Okay, the video is... Okay, so I got the feed on YouTube and we are live on YouTube, and it should be also live on your YouTube as well.
I believe so. It says that we're still in a practice session. I don't know if that means anything.
Can you check if there is anything that shows that you have to go live on your side or
It
click on?
says custom live streaming service on my end.
Okay. It
It's
shows.
yeah, it says that the content of this webinar is being sent to a custom live streaming service.
That's okay. But on YouTube, as long as it's showing live, we are good to go. Okay. Let me also start the webinar so attendees can actually start logging in. When do you go to San Francisco?
I'm flying out on Sunday, but I have a lot of materials to prep tomorrow for it and meetings to schedule. So we'll see.
Okay. Is it like a conference that you're going over there?
So SF Tech Week is like a series of events. Parts of it is hosted by Andreessen Horowitz, like in that group. But it just kind of depends on where we're going to be going. But we're doing a lot of appearances and we're doing a lot of events as well. So
okay. All right. Let me go live on the Facebook group. Just the live video is starting over there. Okay. Okay. Yes, we are live on the Facebook group. Yeah. So live on 3 different platforms. Hello, everyone. Thank you all for joining us live on the Facebook group. 2 YouTube channels, one with Happy Schools channel and other one with Manifest Laws YouTube channel. And also we are live on the F1 Visa Facebook group. And we are also live here on Zoom. So I have Nicole from Manifest Law. We should be getting started in a minute. And we'll talk specifically about O-1 visa. We'll talk about EB-1 visa as well. And we did 2 webinars with the Manifest Law. The first webinar, Nicole, I think we spoke about the H-1B visa layoffs. What happens if you get laid off during H-1B and how do you navigate that? It's very useful session. Nicole gave some fantastic alternatives. The video is also available on Happy Schools YouTube channel. Just search for H-1B layoff, Happy Schools YouTube. You will find it. Also, it's on the F1 Visa Facebook group. You'll be able to find it over there as well. Okay. Also, we did another webinar with the former USCIS officer, specifically talking about the 100K fees. So that webinar is also available with a lot of Q&A that we did for that. Okay, so I think, Nicole, we can get started for today's topic. Hello, everyone. Thank you for joining us on this Friday afternoon. This is a sponsored webinar by Manifest Law. Happy Schools is hosting this event. We are live on multiple platforms, and we have Nicole, experienced immigration attorney from Manifest Law. She will be helping us understand the criteria that is required to qualify for O-1 and then EB-1. Considering that we had a lot of news about H-1B visa over the past couple of weeks. So we have to move over this webinar from the past week, Friday to this week, to give us enough time to digest the news about the 100K fees. But now we have a lot more clarity on that. Now we are focusing on about O-1 visa. Hi, Nicole. Welcome to another webinar. Let's start with the disclaimer, then we do an introduction, and then we'll get going from there.
Right, sure. As a general disclaimer to everyone that's watching, when I give answers, whether it's on questions and the like, and I'm also telling you about the O-1, the O-1B, and the EB-1A, or anything that's related to immigration law and law generally, it doesn't establish an attorney-client relationship between myself and you, nor between our firm and you. We cannot give very specific legal advice. We can give general legal advice. And the other thing I will also note to every single one of you watching, if you're typing up a question or you're submitting a comment, remember that it's public, right? So any confidential information, anything that you don't necessarily want to share, don't put it into the comment or the question. That's better reserved for a consultation or sending a query via email. But just to kind of briefly reintroduce myself to everyone that's here, I am Nicole Ganara, the principal immigration attorney at Manifest Law. We are a tech-forward, tech-centric, and client-centric firm. A lot of our work has to do with building futures for a lot of individuals who want to be in the United States, whether it's living here, working here, residing here, etc. We also work with a lot of companies when it comes to establishing their talent programs. So I'm more than happy to walk everybody through what it looks like to approach the O-1s and the EB-1A.
All right, fantastic. I just changed your name to Attorney Nicole. It was Vicky's name in the start. All right, so, and for the audience who are here, if you have any questions, you have two options. First option is you can go to the Q&A tab here in Zoom, and then you can type in your question. If somebody types in a question, the other audience have the option to upvote that question, so it comes to top of our list. Okay. Also, if you have any questions that you want to quickly ask Nicole, you can raise your hand. I'll give access to your microphone for a short question. So two formats. So we'll go from there. So Nicole, let's get started. What is an O-1 visa, and how is it that different from an H-1B visa?
So an O-1 visa is an extraordinary ability non-immigrant visa. So it's a temporary work visa that is given to individuals who can prove that they're in the top of their field. The reason why that's different, or what's significant about what makes it different to the H-1B, is that there's no lottery process, right? You don't need to submit yourself to a lottery and give it up to chance in order to apply for an O-1. The O-1 you can apply for any time of the year, so long as you qualify for the O-1. In order to, let's say, qualify for the O-1, the government has established a series of criteria, and you need to meet at least 3 of those criteria in order to argue for that O-1 visa. The O-1 visa is valid for up to 3 years, and there's also no limit to the total number of years that you can be on an O-1. So unlike the H-1B, where sometimes what scares a lot of people is that 6-year limit that needs to be broken through a green card process, the O-1 does not have that as well.
Okay, so for instance, if somebody who is on an OPT or STEM OPT, instead of them applying for H-1B lottery and getting H-1B, they are able to get an O-1 visa and continue to work for an employer. Is that right, Nicole?
That is accurate. If they manage to get approved for an O-1, they will be able to work for an employer through that mechanism instead of just an H-1B.
Okay. Is there a lottery process, or is there a cap or a quota for O-1 visa?
Nope, there is no lottery process. There's no cap or a quota for the O-1. The government basically will grant them if you qualify.
Okay. So could you talk about, if O-1 visa doesn't have a cap, it doesn't have to go through lottery process, then why aren't a lot of people applying for O-1? What's stopping them from applying for O-1?
What's stopping people from applying for the O-1, or maybe it's like there's a different answer if it's an employer or an employee, but I would say that for a lot of people, there's a lot of fear, right? Of, am I truly extraordinary? Do I qualify? Because these criteria may seem very, very difficult to achieve. But I do think that that's a little bit of, let's say, I wouldn't say it's a misunderstanding, but a lack of investigation, right? I think it's that if you take a look at some of these criteria and you're given some guidance or direction on how to best build yourself up or establish yourself to meet some of these criteria, it's definitely possible. There's also like this sense of, especially for employers, that somehow these are visas that are easily denied, right? Or they're very, there's a lot of subjectivity, let's say. So you know how the H-1B is very mechanical. You have a job offer, it requires a bachelor's degree, right? And you have the degree and or work experience to fulfill it. It's very much check boxes. there's this sense of like the O-1 is a bit more subjective than that and not as mechanical, and that scares people in a way. However, the statistics have shown otherwise. The most recent statistics that were submitted by the government showed a 94% approval rate still for the fiscal year of 2025 so far. So that means that the government is still steadily adjudicating these to a really high rate of issuance.
Okay. Do you have a statistics about how many O1 visas are typically given in a year compared to a H1?
I don't have those numbers. I will say that there's definitely a larger constituency of people on H-1Bs, but I think it's because H-1Bs are very popular, right? There's a reason why they're being targeted at the moment by the government is because there's a ton of people in the US on H-1Bs, whether it's renewals, extensions, or brand new individuals that are coming onto these petitions. O1s, on the other hand, I would like to think it's like less than 10,000 per year are issued, but I do think it's going to shift very quickly given like the news and the targeting of H1Bs at the moment. But I don't think people should think of it as, oh, lesser number of people means that it's a bad category. It's more so that there's lesser number of people because it's never really been looked upon as much.
Okay, all right. So now, how does somebody qualify for O1? What do they have to do? What are the qualification criteria?
Right. So I mentioned briefly earlier that you have to meet at least 3 criteria out of a set number for that category. So there's 2 types of O1s. There's the O1A and the O1B. And this is a very important distinction. The O1A is for individuals in the sciences, education, business, or athletics. And the O1B is for individuals who have extraordinary achievement in the arts, right? So people who are more on the creative side. There is a subcategory for the O1B for people who are in motion pictures and television, and we can talk about that briefly. But for the most part, for many of you who are watching, I would think that you would likely fall under the O1A category. For the O1A, there are 8 set criteria that people can try to meet, and you need to meet at least 3. So I'll go in order very quickly. So number 1 is that you've received nationally or internationally recognized awards. 2 is membership in associations that require outstanding achievements to join. 3 is press about you in professional or major trade publications or major media. 4 is judging others in the field or allied field in a panel or jury setting. 5 is original contributions of major significance. 6 is authorship of scholarly articles. And 7 is lead critical role at distinguished organizations. And 8 is high remuneration / high salary, where you are paid more than others in your field. Now, a lot of this is very wordy, but the reality is that we're more than happy to talk about like some of the major categories that a lot of students should be focusing on. Because if you read between the lines, a lot of the categories in the O1A reward some level of academics or academia, right? So if you're a student at this time, especially on the F1, cultivating your existing network and the fact that you are in the college environment or recently graduated and you still have access to that network can be extremely powerful to build yourself up towards that O1A.
Okay. So the understanding of somebody who is an F1 currently in school or somebody who's an OPT is I have to have a PhD in order to qualify for O1. Is that the case, Nicole?
That is not the case. I think the reason why there's this misnomer or like this theory that PhDs are somehow the only way to get an O1 is because, like I mentioned, the O1A has a tendency to reward academia, right? Academics, you publishing scholarly publications and the like, and that usually naturally comes through a PhD program or having had a PhD. However, O1s don't care what level of education that you have, right? You could be someone who's really good at what you do, who are in these memberships, who does have press, who have original contributions, and you only have like a high school degree, let's say, or no degree whatsoever. So yeah, you don't have to have a PhD in order to compete for the O1. It's just that I think a lot of people think that because a lot of PhD people in the US may already have O1s or are pursuing the O1.
Okay, so what advice would you give to somebody who is in currently a master's program, knowing that the chances of getting H-1B visa is becoming tougher and challenging.
Hmm.
How can they be better prepared if such an option exists?
I highly recommend networking not only with your professors, but other graduate research assistants, or even like individuals that you may know through your school who are in the PhD programs at your school. And the reason why I say that is because remember that people in academia, people who are scholars, like that's their career track. I'm going to become an adjunct professor, I'm going to be teaching, I'm doing lecturing, or I'm going to be doing research formally as a role at this institution. They naturally have access to databases and opportunities that fulfill the O-1A. And I've never seen people restrict themselves from sharing that insight, right? So a good example is that a professor, especially a really established one, is usually already a member of an editorial board for a journal, right? And if you're already in your master's program and you're set to graduate soon, or you're about to enter your OPT status, right? You can actually ask them, can I get put into the database, like a CMA database, to do peer review, right? Because the professors are usually already part of the editorial board, it's not necessarily that they can fast track it, but they can open up those opportunities and tell you how they do it. A lot of professors also do their own peer review, right? The other thing too is like with the graduate research assistants and the like, sometimes they can show you ways to get research published, both not necessarily in a journal setting, but also in like technical paper settings and industry publications. So if I were in the shoes of a student who is in a master's program, yes, you probably hear this all the time. Networking is very important, but it's targeted networking. Those professors who are truly scholars, those people who are truly in academia and that's their career, they will know how to get you into the right places in order to help fulfill some of these categories.
Okay. Is in master's program, generally there is one path where you take all the courses. There is no research involved. Another structure involves doing a thesis work.
Right.
And another structure is coursework plus a project to graduate with a master's degree. So, given a choice, is there one structure of graduate program preferred, especially for masters, if O1 visa will become eligible, or it'll be easier for them with O1 later down the line?
So I find that those who have thesis projects or research projects may have an easier time because those naturally evolve into opportunities that the O1A seems to appreciate. But I don't want everybody who's watching this to all of a sudden go, oh my God, if I'm doing just courses, is that mean that I'm screwed for the O1? That's not necessarily the case. I actually take a step back when I'm talking to a lot of clients to say, you know, what actually gives you stronger credibility in your career? Right? And the reason why I say that is because usually the better that you build credibility, the more likely that these opportunities that help you build into the O1 are realistic, right? So why do the thesis or the research projects if it has nothing to do with becoming the top of your field at your career? Right? It should be also organic feeling. For a lot of people who are in the practical side of, let's call it engineering, which is a practical field. It's not really like a research oriented field. Sometimes those course tracks or maybe just like the straightforward thesis tracks make more sense because you will open yourself up naturally to opportunities, whether it's meeting other colleagues in the industry who are kind of like the innovators of those spaces, and then they can get you those opportunities like original contributions or lead critical role or high salary versus doing research projects.
Okay, all right. What is the process like? If somebody wants to do O1, and let's say they come to Manifest Law, and an attorney from your team or yourself talks to them. So, how does the logistics of this process look like?
So the first question that I usually ask, like outside of obviously like the criteria analysis, where you give me a lot of information about your background, what is it, what are you doing, or what are you going to be doing, is the question of whether or not you have an employer. Now, for a lot of you, you might start to get confused, which is like wait a second, I thought an O1 could be self-petition. So I'll try to explain like the reason why I asked this question. There are two ways to approach an O1 application. So outside of the O1A and the O1B, it's either A, you have an employer who's willing to sponsor The O-1, so it's a direct employer. It's very similar to the H-1B, where if it's approved, you can only work for that employer for that period of time that you've been approved for. Key difference, though, between the O-1 and the H-1B is that the O-1 doesn't care who pays for the process. Because sometimes the biggest barrier for some employers is that they don't want to expend the cost. In this scenario with the O-1, you can definitely approach your employer and say, well, I'll cover the costs. Would you just be willing to sponsor me? Right? Now, the other way to apply for an O-1 is through something known as an agent petition. So this is where sometimes people feel that, isn't that like self-sponsorship? So I'll try to explain this. In an agent petition, essentially any US company, US citizen can sponsor you or sub in as like the person signing the forms, and can do that if you can prove that you will be working for multiple employers or on freelance and short-term projects. Essentially, an agent is just like a basket. It's just like a company that's out there that's saying, hey, USCIS, right? I'm signing these forms because a lot of different employers or people are interested in working with this particular applicant. And here is the proof that they want to work with multiple people, right? Now, it doesn't necessarily mean that you need to show multiple employers, and where the self-petitioning part comes in is usually one of the offers could be a company that you have an ownership interest in, right? So that's kind of how you work around it, is that there is an offer to you to work, but one of those offers happens to be your own company that you have an ownership interest in. So that's the first question that I ask. And then you talk about, do I meet the criteria? And if you don't meet the criteria, then the conversation that I have next is, so how can I help you, or how can we work together to get that third magical criteria that the government's looking for?
Okay, all right. What kind of evidence are typically the strongest from what you've seen?
So in terms of what kind of evidence is the strongest, or let's say what should students be focusing on, right? I would say number one is definitely judging. Judging is a category that can definitely be realized over a period of time. Peer review is a big aspect to doing that. It's the most straightforward way to do it. However, remember that competitions within your space, hackathons and the like, they actually regularly happen, and they also happen internationally. The government is not saying that you need to do competitions that are only in the United States. You should be able to leverage your knowledge, your experience, and everything that you've done so far, maybe in the US, and you can leverage it at foreign competition settings instead. Other categories that I highly recommend is actually authorship of scholarly articles. But hear me out before everyone goes into the whole, Nicole, I don't have a research paper, I'm not going to get it published in a journal. That's a lot of work. There's a lot of time. I want to implore everyone to know that authorship of scholarly articles also includes non-academic routes. So if you take a look at the guidances, the government says that there's two ways to do scholarly articles, either through academia, which is the normal research journal pathway, or in recognizing that not every single person is in academia, it's in the non-academic route where you argue that I wrote this well-researched paper. So imagine you're a financial analyst or an economist, right? You wrote an op-ed that said the United States should invest in Vietnam for manufacturing instead of China, and here's why, right? You explain those insights and you say, you know, according to a 2022 world report, and you cite to it, blah, blah, blah. Think of it as like a college paper that you submitted for a professor, where it's like well-researched and analyzed and expressed. If that was submitted to, let's say, The Economist, right, which is a famous publication, or any economic publication that's out there, the government is willing to accept an argument, or willing to recognize an argument that that's considered a scholarly publication, because it was written and well-researched, it went through a vetting process, an editorial process, and it was published in a publication that's arguably a trade publication for other industry experts to review. The funny thing is that it doesn't have the same impact if that article was published in like the New York Times. In that perspective, sometimes the government will say, well, that's too mainstream. That's not for industry experts to review. So that is one way to consider making an argument for authorship, because it's not just research publications. It really can be technical publications or well-researched articles that are published in industry. and trade publications as well.
Okay, all right. We got two questions. Let's take those two questions before moving on to the next part. Question one. Can agent petitioner apply for an O-1 visa while employer applies for H-1B? Will this impact H-1B visa?
It depends on how you apply for it, because if the H-1B, let's say, was filed as a change of status, and then you layered another O-1 as a change of status, then the government is going to use the last action rule. How it can affect your employer is that if the employer was expecting you to be on an H-1B to work for them, but all of a sudden you changed status again to an O-1, it's not that you lose your H-1B in the sense that you'll never be able to get it back. It's more so that now you're no longer on the H-1B status if you filed the O-1 change of status afterwards. So you have to be careful for the logistics of it. There's nothing that prevents you legally from filing both applications, but logistically speaking, it can impact your status.
Okay. Could you explain what is a last action rule for those who do not know?
So the government basically takes the last action that you filed or you kind of requested as the last action that you did, right? So essentially, if you filed a change of status on January 1st, right, to an H-1B, but then you filed a change of status to an O-1 on January 2nd, then with the last action rule, that January 2nd filing will be what your status is going to become if it is approved.
Okay. Next question from same person, Ram Nickel. Can O-1 visa be transferred from one employer to another employer in a way that H-1B can be transferred?
An O-1 can file a change of employer application, but unlike the H-1B that has something known as portability, where once you file the change of employer application and it's receipted by the government, you can automatically start working for the new employer while it's pending. The O-1 doesn't have that. For the O-1 is that you file it and you can only start working for the new employer once it's approved.
How long does the process take?
Depends on the case, but if you pay for premium processing, you should get an answer within 15 business days. With regular processing, it does depend on the government backlogs. Could be anywhere from a month to 3 months to 6 months.
Okay. I think Ramanikal, your second question, I'm not sure what you mean by, but anyway, I will ask. How can we know the number of people applied for a specific category, like trying to know the competition?
The government releases Excel sheets every quarter.
Okay. Does that, since there is no cap or quota for O1, it doesn't really matter, right, Nicole?
It doesn't really matter how many people apply.
Okay. What are the most common reasons for O1 denials or RFEs that you have seen?
Generally, it has to do with that. So I'll list what I've seen recently, which is a misunderstanding of the agent petition, right? The agent petition, even though it allows you to substitute just any other company to like sign the paperwork, right, doesn't mean that you don't have to show any sense of employment here in the United States. You need to show that you're going to be doing something here for the next 3 years. You need to show an itinerary at minimum, right? You need to show that the government should be giving you up to 3 years worth of a work visa because you're going to be working here. So it's not enough that you've paid an agency, right, which is it's usually a small fee to sign all the paperwork. And I want to note to people, an O-1 agent is not the same as a Hollywood agent. They're not there to solicit work. Their only role is to literally sign the papers, receive the mail, let's say, for you on behalf of the USCIS filing. You need to show work. And if you don't show that work that's upcoming for you, then the government will RFE it and say, like, what are you doing? Right? Like, what are you planning on doing? The second area that I see a lot of RFEs about is a misunderstanding of how the categories work, right? Truly, when it comes to membership in associations that require outstanding achievements, you need to actually show it requires outstanding achievements to join, right? Many of you may be IEEE members who are senior members. I have not seen senior members be accepted for this category in a long time. Right. And I think it's because the question of what is an outstanding achievement actually needs to be outstanding. Another one that I've seen is lack of evidence substantiating like a claim, right? So if you're going to say that I have a high salary compared to other people in my field, it's not enough that you show your W-2 statements and just call it a day. And you just link like websites that say, oh, you know, Indeed says that I'm in the top 20% or 10%. you need to be able to express to the government not only what the data is, so you tell them it's Indeed, but how did Indeed source that data, right? Like, how did they gather that information that says that you're in the top 10%? Comparables really do matter very significantly, but this also applies to a lot of other categories too. So if you're going to contend, let's say for lead critical role at a distinguished organization, that you're working for a distinguished organization, remember to prove why it's distinguished. You're working for Nike, it's a Fortune 500 company. It's not enough to just say that and to show that it's a Fortune 500 company. You need to explain why a Fortune 500 company matters.
Okay. Question from Jeremy. I have 2 masters in technology, 7 years of work experience in my field, and an employer sponsor. Where should I start in starting work on my qualifications?
So, based on your background and having those years of experience, I would like to think that you probably have an argument already for lead critical role at distinguished organizations, right? You may have a high salary argument already. I would like to think that after 7 years of experience, you've been at least at some point in your career well compensated. Because what I do want to make clear is high salary doesn't have to be current. It could be past salary that you have commanded or will command. But if I had to figure out a third category, considering what you said, genuinely with 2 master's degree, judging shouldn't be difficult to get into those peer review databases. Sometimes they do have like a minimum, let's call it education requirement, and a master's degree would help you out a really long way. So if you're saying, where do I start? That would be the category for you that I would consider. And then I also recommend that you talk to an attorney to actually go through your profile, because you never know if you've actually already met the categories, right? It's very hard to kind of self-measure, because when you're looking at this list of 10 criteria, it's not immediately clear what qualifies for it. So you have to go to the person who is fluent in understanding what the government is looking for to make those judgment calls. Because why spend so much time building if you don't even know for a fact that you may have already qualified?
Okay. So let's say Jeremy starts the process today.
Mm-hmm.
And assuming, just assumption, the person has 2 categories already met. And judging is something that it's not yet met. How long does it typically take for the work that is required for them to be a judge in order to meet the 3rd criteria?
I will say it can depend on the field and also seasons, right? Like, the funny thing is that if you start in like November or December, it might be a little slow for those opportunities because you're in the holiday season, right? I find that the rush kind of starts in like March, like the spring into the summer, of a lot of those opportunities that really open up. However, I would say that for judging, it's one of the faster categories to build up to. If you really treat it as a second job, you can probably get like 10 to 15 peer reviews done in about a 3-month span, 2 to 3 month span. However, it's not like the only factor. Like, when it comes to building up towards an O-1, don't just think about speed. It needs to make sense, logically speaking, how you've acquired these opportunities over a period of time. Because there's something known as sustaining the acclaim. You need to show that you have sustained an acclaim over a period of time in order to really qualify for the O-1 or make the officer feel like you qualify for the O-1. But that would be my answer. If it's like judging, for example, it could be like 2 to 3 months.
Okay, all right. So next question, regarding non-academia publications, could you explain more on these examples if that can be any blog writing on a specific topic like technical architecture, discussions, etc., or what qualifies?
So it has to be an industry publication that you can prove targets or is received by industry experts, right? I'm not a big fan of like media.com, for example. Like, self-publishing is not what the government is looking for. They're looking for publications, right? Where they're actively publishing other people's work after an editorial process. There needs to be a level of vetting, there needs to be a level of review before you can even say that there's an argument that it's a non-academic publication. One thing that I do advise a lot of people is to literally Google the term "write for us" and then put in some keywords related to your niche, right? So if you type into Google, write for us cloud architecture, you'd actually be surprised at how many different publications are starving for content. And they're legitimate publications, whether it's like nonprofit institutions related to your field or genuinely like technical trade publications that even if they only have like 20,000 subscribers, if you can prove a level of credibility, it would make a foundation for a good argument. Listen, all of you guys are really, really smart in STEM. Like that's my perspective. I am kind of jealous in a way. Tell me that you can't put together a script that's going to send an email to every single one of these editors attached with a copy of an article that you drafted and say, hey, are you open to publishing this? Like, let me know, like, if this is something that you would be interested in putting in your online publication. And you will actually see the reaping of those rewards because at least one of them will get back to you.
Okay, fantastic. Can somebody be a postdoc on O-1 visa?
Yeah, I don't see why not. It depends on your history, right? I want to make it clear that there's no like function, right? There's no like specific equation that's like if I do this, right? Or if I am this, it equals O-1, right? Or doesn't equal to O-1. It's really about do I meet at least 3 of these categories, yes or no? If you're a postdoctorate researcher, usually that means that you probably have publications already. You probably are doing something of major significance to your field, and you will probably have access to judging opportunities. I think peer review is usually built into the mechanism of becoming a researcher or a successful researcher.
Okay. What about extension? H1B gets extended. Give me 1 second, Nicole. My son is calling multiple times. Could you answer the question about can someone extend O1 and what's the process to go from O1 to EB1?
So somebody can extend O1s. You can renew it for up to 1 year, but it can actually be renewed up to 3 years total, depending on how you strategize for it. But you need to show that you have work, that you need to show continued sponsorship or continued engagements here in the United States. In terms of transitioning into an EB-1A, it does depend on the circumstances, right? The O-1A has substantially similar requirements to the EB-1A with some slight differences. But if you have a lot of credibility, you've built yourself up, especially here in the US, you can naturally transition to the EB-1A. It isn't a direct automatic transition, though. It's not that if you qualify for the O1, you will qualify for the EB-1A. I want to remind everyone here that the EB-1A is like the pie in the sky, right? It has a higher standard because what you're asking the government is to give you permanent residency. But I do think, Raghu, this is a good segue to explain what makes the EB-1A different from the O1.
Sure. So you get, say, from STEM OPT, either O1 or H1. Then from there, generally what I have seen is O1 is a kind of a pre-qualifier for you to become eligible for EB1. Could you talk specifically about if I have met the criteria for O1, does that mean that I am an EB1 qualified already?
No, it's a good litmus test, right? I think it usually means that you'll have a solid argument to meet at least 3 categories. But I want to make it clear to everyone that they're substantially similar, but it's not the exact same, right? That's the one thing that I have to emphasize. And the biggest difference for the EB-1A is something known as the final merits determination. So the way the EB-1A is structured is that you have to meet 3 criteria out of 10. Right? The additional 2 criteria compared to the O1A is kind of things related to the creative arts and the performing arts. So it's not necessarily as relevant to the target audience here. But what I will say is that even if you meet at least 3 categories based on the arguments that you made for the O1, final merits is a second step review where the officer is tasked with making a judgment call. And it's a very subjective judgment call. They're basically told, do you think that this person will bring a substantial benefit to the United States? And do you feel that this person, despite having met the criteria, is truly someone who's at the top of their field? Right? So even if you met all 10 criteria, you can still be denied on the EB-1A based on that final merits determination. So what I was trying to say earlier to really emphasize to all of you, the O-1 can give you a little bit of a taste, right? An indicator, at least for the criteria analysis, that you have a good argument or a reasonable argument. What it doesn't tell you, though, is whether or not you're going to be able to overcome that final merits determination. Are you truly, truly the top of your field? Another way to kind of visualize it is the O-1 is like, are you the top 10 to 15% of your field? While for the EB-1A, it's like, are you in the top like 1 to 5% of your field?
How do you prove that for EB-1?
For final merits, it's all about what makes you distinguishable, in my point of view. And to be honest with you, it's subjective. It's subjective. There's no rhyme to, in my point of view, or reason, or really, you know, a good metric. Because if you look at the guidances for final merits, a lot of people who are watching right now, you're going to sense that it's very vague. That's why we do find it to be a subjective judgment call. There are some patterns, right? But I think what I will say to every single one of you is that the more that you can show the impact of your work and the influence of your work, and there's a lot of outside affirmations that show and indicate your status within your industry, the more likely that the government will accept and agree that truly at the end of the day, despite having met the requirements, you're at the top of your field. I'll give you like a quick example. If you work at AWS, right, and you're already like one of the higher level engineers, I think it's like L3, right, something like that. If you apply for the O-1, there's a good argument because you have a lead critical role at a distinguished organization. You probably have high salary, and maybe one of the other categories is original contributions of major significance. You've designed something for the company that had a huge impact to the market. But when you apply for the EB-1A, if you're only like a year or two, maybe 3 years into your career, those accolades suddenly don't feel like enough for the EB-1A standard, right? Because yes, you have high salary. Yes, you have a lead and critical role at a distinguished organization, and you might have an original contribution of major significance, but are you actually at the very top of your field? Did you actually have that level of impact? Right? That's why in the EB-1A, they created that second step review, is because they're like, I'm not going to automatically give a green card just because at face value, you technically already qualify for 3 categories.
Okay. Could you help us understand or give an example of a successful O-1 and transition into EB-1? How does that look like? Is there an example at top of your head that this is what helped them qualify for O-1? This is what they have to do to get into EB-1.
So for someone who, I've seen this before, I would say that it started with a person who clearly was like a good engineer. It's like actually a very similar story to like this AWS kind of situation where, okay, yeah, they were highly paid. They're in an industry that is very, very, now it's very much popping up, but early on it was pretty new. It's like artificial intelligence, right? So like artificial intelligence was not necessarily as mainstream 5 years ago even, but that's when they kind of came in. They had lead critical role. The company was arguably distinguished because they had really high powered investors and like a lot of press early on. The person also not only did have high remuneration, but there were like some press features. Like they were quoted in a few things as being one of like the founding engineers, right? Now, even though the O-1 was acquired, to transition to the EB-1A, I remember the conversation that I had with this person, which is like, hold on, like let's take a step back, right? Like I know that you just got the O-1 and you want to immediately apply for the EB-1A because it looks similar. However, you still look very young in your career, in my perspective, right? Having 2 articles that talk about you briefly doesn't indicate to me for an EB-1A standard that you're at the very top of your field. For lead critical role, it's just like time needed to pass, right? You just need to be there longer, or maybe you find different jobs over time, you build other businesses and the like. High salary is high salary. That's more of a technical question, right? So what ended up happening is for them to transition from O-1 to EB-1, they started building into the press even further. let's not just have 2 articles. Let's have 6, 7, 8 articles. And better yet, I said, be much more expansive. Don't just focus on a third category, right? You should have a fourth, a fifth, the more that you can show to prove that you are somebody who's very credible in this industry. So they started doing judging opportunities. They started doing more article writing as well on their own. But then the one thing that I would say really pushed it over, let's call it the limit, like over the hill, right? Was the fact that they started doing nonprofit initiatives, right? Being involved with open source projects that were really impactful, giving back to the community that they were a part of, becoming a board advisor, an advisory member, and mentor to initiatives that the government probably appreciated in a final merits review. Because remember what I said earlier, it's not just about whether or not you meet the criteria, right? Outside affirmations. Are you truly at the top of your field? For you to become an advisor to a known STEM initiative means it's a recognition by an outside organization of your stature and your expertise. One, right? And then separately, what is your benefit to the United States? I'm cultivating the next generation of talent, right? We have a domestic STEM issue here in the United States. Here's what I'm doing to help fix that. So
Okay.
all of those things combined suddenly feels like an EB-1A, and less so my hesitancy relating that transition was definitely lower the moment that those things happened.
Okay. All right. Does your firm Manifest Law help people, say, evaluate if they are eligible for O-1 or EB-1?
Yeah, we do. We do it through our questionnaires. We have some really solid questionnaires and quizzes that we would ask for you to complete. And then we also have attorney consultations. We also have special programs in our organization that allow you to be matched with opportunities. So we do have an evidence development program. It's not for every person. It kind of depends on where you are in your career, how far you are from the O1. So if we feel like, hey, we can just help you out a little bit, let's call it seasoning to get you over the hill, we do have mechanisms in place that can help you with that.
Okay. All right. Another question. Would it make sense to transition from O1 to EB2 or EB3 instead of EB1?
It can. It's just that you would need to keep renewing your O1 while you're waiting, right? I think that just to remind everyone, for EB2 and EB3, the reason why people are hunting for the EB1A is because there are some backlogs for EB2 and EB3, right? So for example, even for rest of the world, so even for people who are not born in India or China, there's still about a 3-year wait time before you can adjust in the EB2 category. So there's nothing wrong with doing EB2 and EB3. That's more than fine to do a green card, but you need to keep renewing your O1 in order to maintain your status here in the United States.
Okay, all right. I'm posting the link on the chat if somebody is interested to get in touch with Nicole and her team in Manifest Law. Please head on to the URL I posted. You'll be able to talk and then probably evaluate what are the chances for O1 or any other options. What's the timeline to apply for I-140 after getting O-1 visa? How does it work?
So the timing depends on how far you are from the EB-1A, right? Or how close you are. But if you were to start putting together an EB-1A, let's say you already qualified, or I think you had a good argument, it usually can take about 2 to 3 months to put together a solid filing. And the reason is because it's a very nuanced application. It's a massive application because just like I said earlier, you're asking for what I call the pie in the sky. Give me a green card because I am extraordinary. So the government does set a high standard. When you file the I-140 application, you can pay for premium processing, which will get you an answer in 15 business days for the EB-1A, when with regular processing could be 6 months, 8 months to a year sometimes for regular processing.
Wow. Okay. All right. So, attendees, any other questions? We have another about 10 minutes to go in our session. If you have any questions, please do post it on the Q&A option. Okay. So, how difficult is for somebody with O1 with one firm and to go to O1 or another firm? Do they have to do the exact same process, or can they take the petition that they have already approved and reuse it with another firm?
They can do that, like reuse a lot of the same materials, but usually you want to update them because the O-1 doesn't say that, oh, you need to only prove that you were extraordinary up to that point. There is an understanding with the government that you consistently and continue to be extraordinary, right? So you can't necessarily take materials that, let's say you applied for the O-1 and got approved in 2017, right? Now you want to change employers in 2019, 2 years later. You should show updated materials. Like, what have you done since 2017 through 2019 and continue therefore, right? So essentially, renewals are not just copy and paste, submit. You need to get updated letters. You need to get updated materials to continue to prove that you are an individual of extraordinary ability.
Does the same advice apply to somebody who is extending with the same employer?
Yes,
Okay.
right? You need to consistently prove that you are extraordinary.
Okay. Next question from Sean. What's the total processing time for O1A from starting preparing to receiving EAD?
You don't get an EAD out of an O-1A. Like when it comes to starting and preparing, I'm going to assume that you mean that you're already qualified for the O-1 and you want to put together the application. It's very similar to the EB-1A where you're looking at 2 to 3 months. And the reason why is because you need recommendation letters. Recommendation letters are what proves that you've done a lead critical role, for example, or that you're somebody who is extraordinary, because that recommender is going to affirm why your achievements matter within your field. And the problem with recommendation letters is that you're relying on a third party. It's not you signing them. You need to have somebody else sign them. So even though us, the attorneys, we draft those letters, for the most part, that third party can comment, can change, make adjustments, or you send it to them and they're on vacation. So that's the timeline.
Okay. If my H1 gets approved and I apply for O1 as well, can I go back to H1 if my O1 gets denied?
I guess it depends on how you applied for the O-1, but if you filed to change your status to the O-1 and you maintain the underlying H-1B the entire time, if the O-1 gets denied, you're still on your H-1B status. But again, emphasis on maintaining your underlying status. You should continue working for your H-1B employer, right? Continue kind of doing your regular job. You can file to change your status to the O-1, but remember that the moment that that O-1 gets approved, it's not like you can continue working for that employer unless that employer was involved with the application, whether through preparing one of the engagements for your agent petition or was the direct sponsor for that O-1.
Okay. Like H1, where there is H4 for the dependents, what do O1 primary visa holders get for the dependents?
They would get an O3 visa.
Does it come with a work authorization like H4 EAD or anything like that?
No, it does not. So that is one of the downsides of an O-1 visa is that dependents do not get work authorization. They can go to school, they can live in the United States, but they can never get work authorization.
Okay. What about the kids? Can they go to high school or go to college?
They can go to high school and they can go to college, but they age out the same way that any dependents would, is by the time they turn 21, they would no longer be able to maintain their O3 statuses. However, for any of you who are out there, generally my advice is that if you have kids who are going to college, it might be better to change them to an F1 so that they have at least 1 year with an I-20 to get OPT. And if they're in a STEM degree program, STEM OPT.
Okay. Like H1B lottery, which is in March, and the status starts in October, is there a timeline of when O1 can be applied, or is it done any time throughout the year?
It can be done at any time throughout the year.
Okay, so there is no lottery, there is no transfer starting on October 1st.
That is correct. There is no lottery. There is no kind of specific timeline, let's call it. It's just you can file for it at any time.
Okay. Can O1 be extended indefinitely?
So I want to clarify this, which is that there's just no limit. Essentially, unlike the H-1B, where you get an initial period of 3 years and it can be extended for another 3 years for a total of 6 years spent in the United States on H-1 status, the O-1 doesn't have a 6-year limit. You can keep renewing it. You can have people who've been on O-1s for like 9 years, 15 years, and that's not an issue so long as you continue to qualify.
Okay. H1B visa allows entrepreneurship. self-sponsorship, let's say you have a company that you startup founder will allow you to apply for H-1B for the company that you founded. Is such provision exist for O-1?
For O-1, this is like something that each practitioner I feel like debates with, but I have a very strong conservative opinion here. In the FAQs for the O-1 on the USCIS website, it literally says that you cannot self-petition for an O-1. However, I think I mentioned this earlier with the agent petition. You can have a company that you have an ownership interest in be one of the companies in an agent petition that is interested in hiring you or giving you a job, right? As an offer. So there is a way to do it. There is a way to be rewarded as a founder for it. It just requires really good logistics and an attorney to structure it.
Okay. Does there need to be a stamping done in the home country for O-1 just like other visas?
Yes, I mean the government rule on this is pretty clear where they want you to go to your home country or country of residence for any stamping. But I actually want to take one step back on this one, which is that I hope everybody here knows that you don't have to do stamping, right? In the sense that if you're here in the United States and you filed a change of status to an O-1 or to an H-1B or to a TN, whatever status it is, right? You only need to do stamping if you leave the country and you try to come back. So if your worry is that I don't want to do stamping, or I hate the idea of doing stamping, or I don't want to get stuck, then don't leave the country.
Okay. Let me look. There are no more questions. Attendees, you got about 5 minutes to post your questions, or you can raise your hand if you don't feel like typing. If you're watching in a mobile device, so it might be tough to type and then listen to this. You mentioned about O1 is also available for artists and athletes. Could you touch upon that a little bit, Nicole?
Yeah, so there's the O-1B visa, which is, to my perspective, it's actually the easier visa to qualify for between the O-1A and the O-1B. So the standard for the O-1B is slightly lower because you need to just show distinction in the arts. So very quickly, just to kind of let everybody know like what the requirements are on the O-1B or what the criteria is one, lead or starring participant in productions or events. Two, recognition of achievements by critical reviews, published materials by or about you in major newspapers and journals. And I want to emphasize the whole by or about you, which is that unlike the O-1A, the O-1B allows you to have articles that you published yourself count as recognition of your achievements if it's published in the right places. Three is lead critical role at distinguished organizations. Four is record of major commercial or critically acclaimed successes. Five is significant recognition from achievements from organizations, critics, government agencies, or other recognized experts, aka recommendation letters. And six, high remuneration / salary. So even though they have a lower number of criteria, a lot of them are like easier in a sense. And actually, I saw a good question come in, which is that does it come for digital artists also in game designing or VFX? Yes, it really does. For you guys who are doing game design or VFX work, if it's a creative endeavor, which I genuinely believe it is, the O-1B can be really, really healthy for you. So I'll give an example of why I think the O-1B is a bit easier is if you take a look at lead starring participant in productions or events and lead critical role at distinguished organizations, those are two separate categories, but you can break down your role into both. So let's say you are a creative strategist at Meta, right? You do a lot of the advertising work for Meta. You can say that you have a lead critical role at a distinguished organization, but you can also make the argument that you were a lead or starring participant in productions because your individual campaigns, let's say you partnered with LVMH or you partnered with Apple on a campaign on Facebook, right? Those individual campaigns are individual productions that I would try to argue for to get that second category, even though it was a part of your role.
Okay. Last question before we wrap today's meeting. Can someone on day one CPT apply for O-1 visa?
I don't see why not. If you qualify and you have a meritorious case, then you should try to apply for it.
Okay, all right. So for attendees who are on live on Zoom or Facebook, YouTube, Nicole is from Manifest Law. If you think you want to give it a try with O-1 visa, absolutely give it a try. Schedule a call with their firm, and somebody can evaluate to see if you are a good candidate for O-1 or EB-1. Nicole, anything else before we wrap up today's meeting?
No, I think, I feel that everybody here should know that my belief and Manifest's belief is that everybody has the capability of becoming extraordinary or being extraordinary. Because at the end of the day, it's all about how much work do you want to put into it? How much effort can you put into it? Because it's all about establishing a level of credibility. There's so many things that can be done to meet the criteria. The government actually lays out that framework in their guidances, right? This is what qualifies. So if you're willing to kind of go through that journey and you want help and support into going into those kind of pathways, creating those roadmaps of how you can get to these criteria, then it's definitely achievable. There's a lot of people who spend a lot of time and effort getting into it, and it's very much possible.
Okay, all right, fantastic. Thank you everyone for joining us today. And thank you, Nicole, for doing another webinar with us. We will definitely meet you again for another interesting topic about immigration. Stay tuned for information about that. Thank you, everyone. Enjoy the weekend. Bye-bye. Bye, Nicole.
Bye.